we'll be talking about some ongoing regulatory developments. And so we have a very strong partner on this already for many years, Timex, represented by Bernd and Pedro. And so the challenge I put to them was to try to help us explaining, again, putting things into the bill of materials concept and context, but also to give you a better perspective and understanding of what the Cyber Resilience Act now really is about, how it will be impacting us both as technology developers, manufacturers, users of technology, and of course, specifically how that will be panning out to the future in the next couple of months. So, Bernd and Pedro, not sure who is going to start, but
I was
okay. You have the controls here. That should normally work. That should normally work. It works.
Yes. So, good afternoon. Bernd and I are going to present today the Cyber Resilience Act. Cyber Resilience Act, as you can see, is a legal proposal by the European Commission to strengthen cybersecurity in the European Union. It's one of the many legal initiatives that the European legislator is now taking. This is our big headache. The cybersecurity is just one small aspect because this concerns the whole digital sector. But of course, many of these rules also contain, many of these legislations also contain rules on cybersecurity, which interact with the cybersecurity column, as you can see. And today, what we are going to present is this small thing in the middle. That's the Cyber Resilience Act. So what are we going to discuss about the Cyber Resilience Act? First of all, the legislative proposal. It's a proposal. It's not yet in force. It's still under negotiation. We will see in a moment how far it is, what it actually wants to do, and how the legislator is finding solutions for certain cybersecurity problems in general. We will look at the basics. So what is it? What does it apply on? It applies to products with digital elements, but what are those? We will see that also. Then the classification, because not all products to which the Cyber Resilience Act applies are the same or are treated the same under this law. Then the roles. So who does this apply to as a person? Not only the products, but of course also the persons developing or the manufacturers of persons selling products with digital elements will fall under the scope. Then the obligations of those parties and also the risks for you and for the companies you might represent. The acceptance. Cannot be identified. Oh, it's fine. Okay, yeah, doesn't matter. So first of all, the legislative proposal. Just for context, I explain how a European law comes into existence. This is the normal procedure. First of all, the European Commission makes a proposal. It sends it to the Parliament. The Parliament will have a look at it. Usually this happens within a small section of the Parliament in a committee that looks at it, specialized in the specific topic, who will then give comments. Where necessary, they will propose amendments. This was done here, as you can see, on the 19th of July. And then the Parliament will vote on this. And then in the second step, there is a first reading by the Council, which is another EU institution. So it's 3 EU institutions working together, the Commission, the Parliament, and the Council, who will make this proposal work, will give amendments, will give input. And the Council is then actually more the national parts, the countries working together, giving their input as well separately. So where we are for the Cyber Resilience Act is the first reading by the Parliament, although the Council has already given some input. So we are still quite early in the proposal. So if we look at what is next, the actual first reading by the Parliament, so where the Parliament will vote on the proposal, as it finds acceptable, will be on the 1st of March 2024, so it's not for immediately. And then also the law for now provides that the Cyber Resilience Act will apply from 36 months from the entry into force, and some reporting obligations after 18 months. So this means that we have still a while to go, but as you will see in a moment, there's not a reason to wait, because many of the topics that the Cyber Resilience Act tries to rule are already relevant today. They will also inspire trust to customers and also into your company as well, and your business partners, in order to ensure that there is some level of cybersecurity. So what is the goal of the Cyber Resilience Act, and why is it there? Well, the Commission recently, as you can see, had a very big interest in the digital sector. This is AI art indeed. I put this in the slide to make it a bit more interesting. So the cybersecurity is a big issue, a big part of the digital sector, and this is also what the European Commission is now trying to rule by different acts. This is just one of those acts, as we saw earlier. So the biggest issue is the fact that there is a growing number of connected devices. Everything is connected. Everything can be like a risk for the cybersecurity. So everything needs to have a same level of protection in order to mitigate the risk as much as possible. So it also said that there was a general low level of cybersecurity in the existing devices, also that the users have little to no understanding of what cybersecurity is. It's mostly the manufacturers or the people selling the products that have this knowledge. And also the fact that the current rules on cybersecurity are a legislative patchwork. This means that there are specific rules, for example, for medical devices, for motor vehicles, but there are no rules that apply across all sectors for now. So the solution is a regulation. The regulation means that it's a law from the EU that applies directly into all countries. It doesn't need to be approved by the countries afterwards. Horizontal. Horizontal means that it applies across all sectors. So independent of whether it's for medical devices or motor vehicles or anything else. So it's also technology neutral. It provides for essential requirements, meaning that what is in the Cyber Resilience Act are minimum requirements. You can always go further as a company in regards to cybersecurity. And then, of course, cybersecurity requirements. So to actually solve the issues, it provides for rules of making available products with digital elements. You will see in a moment what those are. It provides for essential requirements for the design, development, and production of those products, also to actually solve vulnerabilities, and also on market monitoring and enforcement, because without it, companies would not follow the rules. Okay, so the Cyber Resilience Act, of course, does not apply on its own. Some of these laws you may already know, like the General Data Protection Regulation, the AI Act, the NIS2 Directive, which applies for network and information security systems in specific companies, which is also coming into force soon. The rules on product liability, because of course this applies to products. If a product explodes, there is still general rules on liability there. And then it also interacts with what I mentioned earlier, the medical device regulation, the motor vehicle regulation to a certain extent. Yes.
What helps, in my opinion, is to think about NIS2 as a user obligation and CRA as a provider obligation. That helps thinking about it. That simplifies a little bit, and that defines also the relationship between the two.
Yeah, to a certain extent, because the CRA is a provider and also the product itself. And then when the product is actually in use by the customer, then the NIS2.
Then there is a rule for the customer how to use it and keep it secure.
Yeah, indeed.
But it's not limited, because NIS2 will also be applicable to the producer.
Sure. His own operations, yes.
Depends on the sector, but yes. Just to give a very quick example, we have a baby monitor where you have the monitor filming the baby. You have the radio equipment directive because it sends signals on what is happening. You have the GDPR because it's tracking the baby. You have the AI Act if there is some biometric identification, or if the AI is checking if the baby is on its belly and needs to be turned. And then product liability, of course, always if the camera explodes or gets too hot. This sends then signals to the phone, which also has falls under product liability, and then the radio equipment directive, which then has an app. The app has processes personal data, both of the user and the baby. And then this is all sent to the cloud. The cloud falls under NIS2, also GDPR. And all of these will also fall under the Cyber Resilience Act, except the baby.
Not yet.
Yeah. So the basics, the key concepts and roles. What is a product with digital elements, and actually what does the Cyber Resilience Act apply to? So a product with digital elements, we will see later. But the Cyber Resilience Act starts with the fact that it says the product with digital elements that is made available on the market, so a product that is sold in the European Union, and that can have a direct or indirect data connection to a device or network. So it's both with a cable, via Wi-Fi, via Bluetooth, it could be any connection. Then a product with digital elements is a very, very broadly defined concept. It applies to both hardware and software. And as well as it remotes data processing solutions. So meaning that if a hardware or software sends data to the cloud, it will probably also fall under it, as you will see in a moment, as well as the components that are placed on the market separately. So what is a remote data processing solution for the Cyber Resilience Act? The remote data processing solution is the solution that is used in conjunction with the product with digital elements and helps it with providing its function. So a very simple example, this Garmin watch is a product with digital elements. It's hardware, it has software on it. Both fall under the Cyber Resilience Act, but this always sends data to Garmin Connect. Garmin Connect also does certain calculations, sends me extra data, and that's one or more of the functionalities that are provided to me, meaning that this cloud solution, the software as a service, also falls under the scope of the Cyber Resilience Act. But as a general rule, it does not apply to SaaS, PaaS, and IaaS. You have a question? But it's important to note that, of course, those as a service solutions always fall under the NIS2, which is another topic.
And cloud tech.
And then we have some very specific topics. The first one is free and open source software. Generally is excluded, except where it's provided as part of a commercial activity. The commercial activity is defined based on the development model. So who is developing it? Is it a central company exercising control over the open source? Or is it multiple persons working together with no centralized person having control? If it's the company, it's usually commercial. If it's people working together on GitHub, then it usually is not commercial. Also, if you charge a price for the software, it will usually be commercial. If you're not charging a price, but you charge a price for support, then it's also commercial. And then the Cyber Resilience Act also specifies, just to be certain, that the sole act of hosting free and open source software and open repositories is not a commercial activity. And then we have prototypes. Prototypes falls apart into two types. You have the prototypes as such, which should be understood as hardware, and then we have the unfinished software. Both fall outside the scope if these limited criteria are applied. So meaning that the prototypes fall outside when the scope, when their use and their availability is limited in time and then the geographical area. If it's clear that it's only for testing, and also if there is a visible sign indicating non-compliance. And then in a similar way, this applies to unfinished software, where again, it's free of charge. That's not for the prototypes. When again, it's limited to the testing period, and there is a visible sign indicating that it does not comply with the Cyber Resilience Act, and that it will not be available for other purposes than just testing. And then spare parts. Spare parts also are excluded. but only to the extent that those spare parts are provided by the original manufacturer to replace the identical parts, because of course the original manufacturer already did an assessment of whether this part is secure, and no further assessments will be required in relation to that part. This is to enhance the repairability and durability of products with digital elements. So PDEs are products with digital elements.
So as it usually happens, those parts are subject to versioning. Usually you get a different version when you do a replacement. So that replacement needs to be qualified again.
Usually, if it brings a substantial modification, yes.
Yeah, right.
We will also see this a bit further. But if it's the exact same part, like,
Then it doesn't.
then
Yeah.
it's okay.
Yeah.
But of course, not all products with digital elements are the same. They are classified under different categories. The Cyber Resilience Act makes a distinction between the general products with digital elements and then the critical products with digital elements. The critical products with digital elements are subdivided into different classes. The first one, the second, and then the highly critical products with digital elements. The highly critical products, they are not yet defined. This is something that the Commission will do later and then every 2 years. But we already have an indication of what the class 1 and class 2 critical products with digital elements will be. So the class 1 are general products that are critical, while the class 2 are really the products that are at the core of society, internet, and of security, like the secure elements, for example, in your smartphone, your operating systems that ensure that your computer, for example, actually works. And there is also an overlap with the NIS2 directive, because if you supply certain products with digital elements to a company that qualifies as an important or essential entity under NIS2, it will also be considered a critical product with digital elements. So it's not only what the product does, but could also be who am I providing it to, so that will impact your analysis. And then, yeah, you have the class 1, you have the password managers, firewalls, network interfaces. There is a whole list in the annexes. And then your general product with digital elements are just, yeah, everyday stuff like photo editing software, smart speaker, games. Yes. So critical is assessed on the basis, the criticality is assessed on the basis of the negative impact that the exploitation of a vulnerability could have on the functionality, and then also the intended use by the user. It's important for the criticality to look at the core functionality, meaning that if you implement a secure element into your hardware, it doesn't mean that your hardware as a whole would become a critical product with digital elements. It's only the secure element as such that is the product with digital, the critical product with digital elements. Your smartphone might fall under the general product category.
But the typical question here, the intended use. So say you use a smartphone or a smart speaker in a nuclear facility.
But you don't take it into account as the manufacturer in that case.
That's the issue.
It should be reasonably foreseeable, and
so you should then mention you should not use this for nuclear facilities.
If that's reasonably foreseeable, yes.
Okay.
Also, that's
So
a
there's
vague concept in the Cyber Resilience Act.
Yeah.
Many aspects are still undecided, or they write this will be subject to guidance by the European Commission. And that comes usually some 6 months or later after the entry into force.
Yep.
So just for some context, the critical products with digital elements will be around 10% according to the Commission of the products with digital elements, while all the others are around 90%. So just for your general understanding, if you have a computer, you have your hardware, you have your operating system and software on there. All of these are products with digital elements under the Cyber Resilience Act, as well as the laptop itself. And these, for example, would then be critical products with digital elements because they make sure that your computer actually provides its base functionality. And then we can also shortly go over the roles. So they are called, the people who are actually working with the products with digital elements are called the operators. The manufacturers are the ones that make the products with digital elements, or who design them and have them made. Then you have the importers. The importers are the ones who import them in the European Union. If you import, for example, a Chinese product to place it on the market, then you're not the manufacturer, but of course the importer. The importers have specific obligations based on what the product is and may have to request the manufacturer to provide information to ensure that it's compliant with the Cyber Resilience Act. So this means that also products from outside the EU that are imported will fall under the obligations. And then you have the distributors. Those are already in the European Union, and those are just the people selling the products with digital elements. Specifically here, I guess most of you people will be considered manufacturers if you ever make a software or hardware and then place it on the market or have it placed on the market. It's also important to note that importers and distributors placing their name or trademark on the product with digital elements or who carry out substantial modifications, so you will see in a moment what this means, can be seen as manufacturers. The same is true if you are a company or a natural person who does the same, who carries out substantial modifications. You can also be considered a manufacturer if you place it on the market later. So a risk could be if you provide some code on GitHub. There's code on GitHub, you change it a bit, and then you place it there again and then provide support on it, paid, then you could be considered a manufacturer and you have to comply with all the obligations in the Cyber Resilience Act. You also have representatives. This is just a way for the manufacturers to give away some responsibilities to another party. It's a contract that is concluded with the representative, and the representative will usually take control of the communications with the authorities. Also then, in relation to the authorities, all the economic operators, so the manufacturers, importers, distributors, and representatives need to provide information to those authorities on who they provided products for digital elements with and who they received them from. So you need to keep track of this, and this has to be done for a duration of 10 years. But we will go deeper into the specific obligations in a moment. Then we have the other side, that's more the governmental and conformity assessment. And yes?
Still have a question on the job side. We are working with a lot of students.
Yes.
They have produced a lot of code, hardware and software, possibly publicly available on GitHub.
Mm-hmm.
Do they also create these?
Only if it's for commercial purpose, and I guess they usually just make it under open source software that is, usually it's an open source license, no?
Usually that is nothing.
Ah.
No, it's just
for their own usage or experimentation or learning.
to get grades. You just say, if you don't mind that we can get it, we can look at it.
Well, then you have to go back to one of the earlier slides, and then you look at the fact that just putting your software on there is not a commercial activity. If they do not ask money or do not ask money for support or anything else, then it should be fine. Question? No. So it should be fine. And then you have the other side. This is the administrative bodies and the government. You have the conformity assessment bodies, because once you place a product with digital elements, but once you want to place it on the market, it needs to be assessed. This can be done sometimes by the company itself. Sometimes it has to be done by a third party. The third party who does this is the assessment bodies. And these are under the control of the notifying authority. So that's a government authority that will check whether the conformity assessment bodies actually do their work, if they do it correctly, if they're not paid by the company to give a conformity assessment report that is just compliant, but without actually being compliant, stuff like that. And then the big guy on the other side is the market surveillance authority. That's the authority that will actually enforce the Cyber Resilience Act. It cooperates on the European level and also with the other authorities at the national level. And as Bernd will explain later, they are able to fine you or to obligate you to take away your product from the market, for example. And at the European level, that's then the role taken up by the Commission, who is supported by ENISA, the cybersecurity authority.
Yeah, so that's enforcement, and that really means it's not just do what you want and this is the rules, but you do what you want. No, you don't do what you want, you can be enforced.
Yeah, indeed.
Which is good.
They wanted to make it similar to the GDPR to ensure that it's actually enforced.
Used, yeah.
But actually, yeah, used.
Applied.
Applied, that's the word. Yeah.
Yeah, actually. I take the floor. So, does it work?
No.
It does work. So, once you fall under the scope of the CRA, question is, what do you need to do? So there are certain obligations, and we can make a distinction between substantive obligations and reporting obligations. So substantive obligations are more like general obligations, like what should you do before placing a PDE on the market? What should you do during the support period? And what should you do thereafter? And then we also have reporting obligations. So let's say there is a vulnerability that's identified. How and when and to whom should you notify those vulnerabilities? So that was my part.
Okay, so the Cyber Resilience Act, to ensure compliance with cyber security requirements, imposes some minimum requirements, which are the essential cybersecurity requirements. They are subject to a conformity assessment, meaning that either the company or the conformity assessment body will have to check whether the product with digital elements is compliant with those essential cybersecurity requirements. And that is then done based on different lists with questions, which will depend on whether the product with digital elements is a normal one or critical 1, critical 2. There is a very long list of obligations. The basis for this list is there should be an appropriate level of cybersecurity based on the risks identified. So the risks need to be identified during the whole lifetime of the product, already at the design phase, actually. And when the product needs to be put on the market, the manufacturer needs to do this when in a way that there is no known vulnerabilities. There should be a secure default configuration. This means not that it should be at its securest, the product, but that there should be a minimum level that takes into account the risks. This minimum secure default configuration should also stay applied after, for example, a reset, meaning that the phone, for example, if you reset it, shouldn't be going back in its security of 2018 if it's a very old phone. There should be a functional separation of security and functionality updates. This is what some phone manufacturers already do as well, where you can upgrade to iOS 17 or stay at under 16 and only do the security updates. Those security updates should be automatic. There should be encryption on processed data, both in transit and at rest. Then there should be protection of the essential and basic functions, meaning that if your phone gets compromised, it should, as much as possible, still be able to make calls and SMSs, where the whole digital part, for example, would be compromised. There should be logging capabilities in your product with digital elements. This is specifically important in products with software, of course. And then it should also allow the user to withdraw and remove its data when it wishes on a permanent basis, which also works together with the GDPR, where you need to be able to control your personal data. But here, of course, it's applicable to both personal and non-personal data. Yes?
My question on the automatic security updates.
Yes.
Should we push that from a manufacturer's perspective? Say we have users,
It
they don't want to update.
no, there should be a possibility for them to opt out from it, but the default setting should be automatic.
So okay, so as a manufacturer, should we give the client something zero knowledge kind of things for them to attest it independently, or they have to depend on the manufacturer for the verifiability of the product, let's say. So for example, if we sell some kind of software and we tell them that this is fine, what would be the way for them to verify our claims?
They usually don't. What they will see is the CE label, which you also see on other products, to say that it's in compliance with the European regulations. They can maybe with the consent of the company do some tests like penetration testing and then see what the issues are, but
The
Of course.
compliance, there's no record of the compliance.
there is a
Yeah.
record at the company, but the company is not under the
Right.
Cyber Resilience Act obligated to share it. Of
Okay.
course, as a business, it's useful to share to a certain extent how secure your device is, for example, but
And of course, there's always the authority. So someone could complain, file a complaint with the authority, and then the authority can do an inspection to see whether it's all secure and whether you comply with the rules. So it's more. I think that's more like a task for the authority.
But
to
the
find
right
out.
of the customer is very limited. You have your normal obligations under contract law where you need to be sufficiently transparent, but you don't have to provide them the full technical part of your product. But you need to have it as a company, as you will see later. Yes.
About vulnerabilities. Here it says that there shouldn't be any single non-exploitable vulnerability, but that's something that constantly changes and
Yes.
new vulnerabilities can be.
Pedro, can you repeat the question?
Yes. So the question is, how do you ensure that there is no known exploitable vulnerability, because the landscape constantly changes and the risks as well. So it's at the moment of placing it on the market here, or at the moment of the assessment actually.
So if something happens later on, there are no.
Then-
Well,
then
then,
you-
then we
you-
go to the next part, and
Yeah.
that's the vulnerability handling.
Yeah. Because this point, it also struck my attention when I read the text. We talked about it in the office, because of course, there are always vulnerabilities in a system. So it would be impossible to require that you never put something on the market with vulnerabilities. But of course, once they are identified, they become known. And then of course, you should act and report whatever is necessary and do whatever is necessary to remediate that vulnerability.
The vulnerabilities can be created as a result of a combination of, let's say, changes or updates in different elements
Yes.
of the product. So
Yes, of course.
you cannot know
It's
them-
an ongoing exercise.
you
It's
cannot know
not,
them all at the beginning.
no,
No.
You
no.
need to
There
monitor-
are always
there
vulnerabilities. It's
will
just,
always be
yeah.
the ones that will be discovered.
Yeah, exactly.
Can I
Yeah.
also answer that question?
Sorry?
Can I also answer that question?
Yeah.
Sure.
Because like when I first came to Belgium, I was working for a how can I say, not a secret level defense company in Turkey. So I was working here as a penetration tester and source code review application security engineer. So this is how we work. So every day we have some automated vulnerability scanners. So they scan the public facing web applications, net services, and post, etc. And just before every developer makes a commit in their and they develop softwares, we had like source composition analysis, SAS tools, etc. And just before every release, we had penetration testing, and this is how we make sure that this is a vulnerability-free
Yeah.
environment.
But it shouldn't always be this far, because of course it's based on the risks. So
Yeah. Yeah, so that's a very good thing to do, but is also risk-based, and doing a pen test before every release wouldn't be possible for every company, you know.
Yeah,
But
yeah,
for some big large organizations with a huge budget, you could say, yeah, based on the risk, that's a very wise thing to do. But for a startup, that would be too much.
Yeah, too much money, because it's one of the obligations, because at that time, my ex-company had a collaboration with Lockheed Martin company, which produces the F-35 jets, right, or something.
Yeah.
So this is one of the obligated.
Yeah, that's a very high risk. Yeah, that's a very high risk.
But there are some like source codes related to F-35.
Yeah.
In my ex-company, so.
It's a small side note. It doesn't apply to those jets, the CRA, because it's for military purposes and it's a specific exclusion. Just so you know.
Yeah, because you have specific laws for
the
military.
The approach is interesting to note.
Which
approach? Your approach is interesting to note. I think it is, you know, if someone wants to be really rigorous about his software, then I think that's a super approach.
If you have the means.
Yeah, well, you can automate a lot today, right?
Yeah, I thought my task at that time to automate those type of activities.
Yeah.
As much as possible, of course.
Yeah.
Expect the call.
Yeah.
Just kidding.
Thank you.
So other than the essential requirements, there is also the vulnerability handling requirements. And this is where we arrive at your topic of today, the SBOMs. This is also the first time that an SBOM is defined in the law. It's defined as a formal record containing details and supply chain relationships of the components, including the software elements of a PDE. So, yeah, I don't know if you agree with this definition. Maybe we can discuss this later. It's a very vague definition. It's very open because there's very different ways to make an SBOM. The Commission has stated in the CRA that it will give some guidance on how to do this, or at least the minimum elements that should be in there. There is an obligation also to notify entities maintaining the specific components that you identified in your SBOM if you identify a vulnerability. This is part of your own vulnerability handling requirements. And the SBOM should at least be written down in a commonly used and machine-readable format. This is general wording of the Commission, probably because it wants it to be able to be easily read by artificial intelligence systems. And it should cover at least the top-level dependencies of your product to digital elements. In addition to the SBOM, to have an SBOM in general, of course, as we stated earlier, the SBOM, it's an internal document. You don't have to share it necessarily with the companies you contract with. You can share certain parts of it just to inspire some trust and say, look, our product to digital elements is secure. But it's an internal document that you as a company need for yourself to handle vulnerabilities, but also to share with the authorities, of course, if requested. You have to do regular testing and reviews. You have to share and disclose information with the authorities when you solved an issue. This is to also help other companies once your issue is solved, of course, to show how they can solve their issues and what issues exist with your existed in your product. This information should, under certain circumstances, also be disclosed to your customers, but only afterwards. And you should also disclose this when you do, for example, a security software update. This is also something that phone manufacturers are still saying we solved certain issues. Then you also need to put in place a policy on coordinated vulnerability disclosure. So if someone comes to you and says, hey, I found an issue in your software, like what you are doing, usually the company cannot retaliate against you. But like what you do, spray zone. And And then issues should be addressed free of charge in relation to consumers, at least. In business-to-business relationships, there can be other contractual provisions where the company wants a bit more money for identifying and addressing issues. Yes.
So, top-level dependencies is not a lot, right? If we look at how software is made, we know that you can decompose it in components, and you can depict that in a tree structure. The tree structure can be pretty deep, right? You can have, subroutines and subprograms and so on. So it can go very deep. Top level is only top level. So
yeah.
Basically it says if I use a commercial library from this or that company, then I need to realize that I use it, and maybe I need to test it. Probably the testing is more useful than the SBOM in itself, because the top level SBOM is very superficial. It raises maybe just awareness that you have been buying or using software components from other people, and it will maybe incite you or give you the hint that you need to test it or need to research how secure that is. It maybe give you ideas, but it remains very superficial. So I think the testing is probably more useful, and the user testing is also useful. That is why the vulnerabilities will come up, probably. If you make software from scratch, then of course you can do the tree structure also from top to bottom. Unless you're a software guy, how do you look at that?
I agree with you that we tend to use this libraries quite a lot.
Yeah.
But then, in our defense, I would say that we always look for this public
Right. So you have a
open source kind of.
You have a big probability that something would have been discovered by others.
Yeah.
Yeah.
It's like distributed trust in a sense.
Yeah. So that's helpful as well.
It's part of your risk management.
Yeah. So when we say, we also highlight this point with open source and all those things, you can test it if you want to.
Yeah, which means that you don't know everything. That there is a big chance that it would have been discovered.
Yeah.
That's good.
But it's minimum requirement, so you can go deeper if you want. But yeah, it's more work. So, and then one last part on the substantial modification. As we explained earlier, certain actors can become manufacturers if they place their trademark on there or do a substantial modification to the product to digital elements. It can also happen to you if you do this change and then place it on the market. So a substantial modification has its own definition under Cyber Resilience Act. It means that the product to digital elements is modified in a way that was not foreseen by the manufacturer. So it does something else than what was in the documentation usual that the manufacturer should have under the CRA. And also, it should be a change that leads to the fact that it no longer meets the relevant essential requirements, meaning the requirements we mentioned earlier, or any additional requirements that might apply specifically to your product to digital elements. So for software, the CRA specifically states that where you have software and you provide new versions with minor improvements and bug fixes, the functionality stays the same. It will not be a substantial modification. If you do a real refurbishing, for example, of a phone, which is then hardware, or do some repairs on it, which brings it back to its original state as intended by the manufacturer, it's also not an issue. But then upgrading of software or really changing the component or putting another component in an original project, in an original product, may lead to this substantial modification. Of course, this is very broad. If you apply it, you will probably encounter some issues. Again, the European Commission stated that they will provide some guidance on this in the future, but this may take a while.
One more question, because I do not know whether it fits into this. So for example, this big companies, when we use the software.
Please repeat the question again. Thanks.
For you, yes.
Yeah, so this big company, for example, I don't want to name, but let's say all the big names that we use in our daily lives, so they can change the user contract by themselves. And what will happen in that regard?
Okay.
So
So-
the question was if as a software provider, if I use software from another big company, and that big company has the right to change the software agreement on its own initiative without asking for permission, how does the responsibility then trickle through to my own product when I use them as a component?
So it depends. If the contract is purely changed from a legal perspective, there is no issues. If it has an impact on the actual product to digital elements, it might mean a change. But you have to look from the perspective of the product to digital elements itself, not from the perspective of the contract. Or
Makes sense.
is there something I'm not understanding from your question? You always start from the product to digital elements. The legal part is extra for this law, at least.
Yeah, understood. The remote audience. Well, let's assume that's a yes.
Okay, so now we know what the essential cybersecurity requirements are, but what do we need to do with them? So one of the first obligations that you have is that you have to document these requirements, meaning in a cybersecurity risk assessment. So in that risk assessment, you're going to explain like, okay, how does our PDE comply with these requirements? If a manufacturer, if they know, or this is important, or if they have a reason to believe that the PDE is not in conformity with the requirements, they have to take immediate action. They have to take corrective measures, and even if necessary, they have to withdraw or recall the PDE. So that could be quite drastic. So under the CRA, the manufacturer has some kind of accountability obligations, just like what exists under the GDPR. And that means that they have to provide all information to the authority if they receive a question like, do you comply with the CRA? Show me how you comply with the CRA. They have to provide all the information and documentation to the authority. But this request for from the authority, it should be reasoned. So they should have a reason. They should explain why they ask you this question. So it's not like they can say, well, because we say so. It's not a valid reason. So it should be reasoned. This cybersecurity assessment, it should be in a language easily understood by the authority. So I put English question mark. We don't know what it means. And it could well be that this is a court case waiting to happen. Imagine the authority in Belgium is bilingual, French speaking, Dutch speaking. Your case with a French speaking person, could they then say, okay, I don't understand French, I don't understand Dutch. Can you provide me the risk assessment in French? I mean, I think the baseline should be that it can be in English. I mean, most companies, they have English as their business language, and in practice, most cybersecurity risk assessments will be in English. If we look at GDPR, where you have data protection impact assessments, for most of our clients, we also make them in English. And usually it is tolerated by the authority to have it in English, even if it's not like an official language in Belgium.
I have another suggestion about this. It is not only about languages, but it's also the way the language is used. I have some experience with the French legal language. It is absolutely not understandable. if you know French very well, you write it without errors since 20 years, and you read a legal text, you don't understand what it is about. It is just not understandable, or let's say it's very difficult to understand. So understandable also means no very specific.
I see your point.
See what I mean?
Yeah, I definitely see your point. But in a cybersecurity risk assessment, that's not a legal obligation. If we look at another obligation, which is I think point 7 in the slide, you will see that there are some obligations to inform users of the PDE, and that information should be in very clear, simple language. There is a legal obligation, but as a company, you are allowed to make this as complicated as you want. But of course, the authority will pose a lot of questions. If you make it very complicated, you can expect that you have to explain a lot to the authority. So whereas it's not a legal obligation, it's probably a wise thing to take that into account and to make it readable for not only technical people, but also legal people with a more legal kind of background. Then you should also cooperate with the authority on any measures taken to eliminate the cybersecurity risks. I'm not sure what this means. Does it mean that the authority can tell you what measure you have to implement and you have to cooperate with it? Or do you have to tell the authority what kind of measure you are going to implement? So that's not very clear to me at this point in time. Second obligation, so you have to carry out and document a cybersecurity risk assessment, which I just explained to you. And this basically answers the question, how do PDEs, so products with digital elements, comply with these essential requirements? Important to note here is that you have to take the outcome of this assessment into account already during the planning. Also during the design, development, production, delivery, maintenance, but already during the planning. So that means that you have to draft this risk assessment very early on. This is of course, to minimize the risks, to prevent incidents, and to minimize the impact of such incidents. This cybersecurity risk assessment, it also needs to be part of technical documentation, which is another obligation we will explain later on. And this is an ongoing exercise. Ongoing, by that I mean during the support period. So it's not an like an indefinite period of time. It's only during the support period. So if they discover new vulnerabilities during the life cycle, during the support period, you have to update. You have to come back to this risk assessment, and you have to make sure that it's updated. Then I already mentioned the term support period. You have to determine this support period as a manufacturer, which also got a legal definition now. So support period means the period during which the manufacturer ensures that vulnerabilities of the product with digital elements are handled effectively and in accordance with the essential requirements set out in the annex. And that annex is basically explains the vulnerability handling requirements. So in other words, during the support period, you have to resolve any security issues. Okay, so you have to determine this period, but how long should this period be? Well, the law says it has to be proportionate to the expected product lifetime. As you can imagine, that's different for maybe a smartphone compared to a car. I mean, it depends on the product, and it should be in line with the nature of the product, users' expectations, availability of the operating environment, and the support period of the main components integrated in the PD. So this support period, you have to, as a manufacturer, you have to determine yourself how long you are going to support this PDE. But it's not, let's take the example of a smartphone. Nowadays, I think for most smartphones is 3, 4, 5 years of support. I mean, you don't have smartphones with 1 year of security updates. So I think that would not be in line with what you can expect from a smartphone today. So this support period, you have to be transparent about it. So it should be clearly stated on the product packaging or in the agreement. So, you know, you all agree these terms and conditions. They should mention the support period. And in any case, just putting it in the terms and conditions is not sufficient. You also have to inform the end user before they make the purchase, so that they are very well informed how long they can expect support from you. And there it doesn't end, because at the end of the support period, you have to actively inform the end user. So that means that you should, I don't know, should send a notification or an email, whatever, saying your support has ended. So this needs to be, this is an active obligation. And if the support period is less than 5 years, the law provides the possibility that you give access to your source code to a third party for security updates. Don't worry, this is not a legal obligation. This is just a possibility. In that case, you should, of course, sign a contractual agreement with that third party to make sure that they are not going to steal your source code. They should only use it for those security updates, which is obvious. A fourth obligation, you have to do a due diligence when you integrate components from a third party in your PDE. And this also applies to free and open source components. So when you're integrating open source components in your PDE, you have to be a bit careful. So you should not integrate any components that are clearly insecure. So you can do this by checking whether the component has a CE marking. You can check the security updates. You can check whether it's free from known vulnerabilities in the vulnerability database. And you can carry out additional security tests. Again, these are possibilities. These are not legal obligations. So it always depends on, okay, what's the risk? Is it an important component or is it like a less important component? So due diligence means that you have to be a bit careful. And why is this? Why is that? Because when you integrate those components in your PDE, it means that you, as a PDE manufacturer, you become responsible once it's placed on the market. So you cannot say like, okay, it has nothing to do with our product, it was a component. No, it's your responsibility. On the other hand, the component manufacturer, they cannot say, it's not my problem, you are responsible. No, they have, of course, they have to assist the PDE manufacturer to comply with this due diligence obligation. And they have to do it free of charge. So they cannot say, I'm going to charge you a lot of money to provide you with this information. Fifth obligation, you have to remediate vulnerabilities. Means that you have to have in place policies and procedures, whether or not it's notified, the vulnerability is notified internally or externally, doesn't matter. And if it's a PDE for consumers, so for use by consumers, you have to have security updates by default. A bit comparable to what we know in the GDPR, like data protection by default, you have to apply security updates by default, but with the possibility to deactivate this for the user. Sixth obligation, it was already mentioned, you have to draw up technical documentation. What should be in there? Well, for instance, the already mentioned cybersecurity risk assessment, but also how you have to provide information about how you are handling, what's the process for handling vulnerabilities, including the SBOM, a policy, and so on. When do you have to draw up this technical documentation? Before you place a PDE on the market, which is obvious, and then you have to carry out the conformity assessment, which Pedro already explained. Very important, this technical documentation, you have to keep it at the disposal of the authority. So if they request it, you should be able to give it to them. But if you provide them with the technical documentation, they should make sure that they keep it confidential. And very important, I already mentioned the support period, but this technical documentation, you should keep it for at least 10 years. So even if the support period is 5 years, doesn't mean that after those 5 years, you can say, okay, support has ended, we delete everything. No, you have to keep it for at least 10 years. And if the support period is longer than 10 years, you have to keep it as long as the support period is. Here is the complete list if you want to read it, or what should be in the technical documentation. I'm not going to read it. Yeah.
You mentioned that the component provider has to provide assistance to the charge.
Yes.
Just before that, because it also applies to open source software.
Can you repeat quickly the question?
So the question is, I'll go back to the slide. Even more back. It's this slide, right? So the question was, I said that the component manufacturer, that they have an obligation to assist the PDE manufacturer, and they should do it free of charge. Does it also apply to open source components? As far as I can tell, yes, it does.
They are provided for a commercial activity, yeah? Only if they fall in the scope of the PDE, I would say.
But yeah, if you take a permissive open source license, then commercial activities are allowed. But then
No, but is the person granting the license giving it as a commercial activity, or is it just like, here is my software, use it however you want?
Yeah, well, that's in the permissive license, of course.
Yeah, but you can still say, I provide support to you if you pay me. That's not in the license. Then it's for commercial, but it's just the permissive license without any payment, or it does not qualify, as I explained earlier, as a commercial activity, then it should be fine.
Yeah, in the slide it says also applies
to open source.
No commercial.
Yeah, that's at least that's how it's written in the CRA now.
Oh, okay.
But you have to. I'm not sure whether it was already mentioned. The text that we have now is not the final text. So we still need discussions between council and so on. So it could well be that this is not what that someone sees this. Maybe you should make a comment. Yeah, it could still change, but that's what the text mentions at this moment. So yeah.
What you said makes sense.
Yeah,
If
yeah.
you give your
I
stuff
think.
for free, how can they ask you to provide support?
Yeah, I see your point. Yeah. Yeah. So maybe you shouldn't give anything for free anymore then.
Don't use open source.
Yeah, yeah. Okay, where were we? For technical documentation. 7th obligation, you have to provide information and instructions to the user. What should you tell the user? Well, as a minimum, I give some examples. you have to inform the user who's a SPOC for reporting cybersecurity vulnerabilities. And interesting here is that the manufacturer should not solely rely on automated tools. So it's not like they can say like go to a chatbot and figure it out. No, you should not rely solely on automated tools. If and where applicable, where the authority can consult the SBOM. So if it's public, where the authority can consult it, and the support period, there are many other things that you have to tell the user, which are here on the slide. Well, in what form? It could be in electronic form or physical form, but if it's in an electronic form, it should be in a user-friendly format, which means that the user should be able to consult it online, download it, save it, and print it. So you have to make sure that it's very user-friendly. So you even have to support that the instructions can be printed. And it should be able to consult these instructions during the support period online. So then we come back to the question about language. So it should be in a language which can easily be understood by users. And then we mean here we mean like a language like English, French, Dutch, or any other language. But that's not sufficient enough. It should also be clear, understandable, and so on and so on. So it basically means you have to make it very easy for even your grandmother to understand. Yeah, you have to mention URL for the EU declaration. Then, last but not least, you have to identify and document vulnerabilities and components in the PDE, and you have to comply with the required SBOM specifications. So I will not repeat the legal definition of an SBOM, which was already explained by Pedro. Also, if you read the regulation, they acknowledge the benefits of an SBOM, but they they recognize that it is of particular importance for manufacturers to ensure that their products do not contain vulnerable components developed by third parties. But manufacturers should not be obliged to make this SBOM public, because that could, of course, be an additional risk.
Yeah, that's an IP risk, mainly, I think. It is a risk of explaining to everyone how you made your product, which is of course not something.
Yeah, that, and it could also be a cybersecurity risk, of course.
Could also be
because it could be used to search for vulnerabilities for some of the components, and such it can be an additional cybersecurity risk.
Does it mean that we as company can decide whether to provide this to someone else?
Yeah.
Yeah.
Unless it's the authority, and you have to, if they have.
Question.
Yeah.
Just quickly repeat the question. The question was, can I, as a company who provide a product with digital elements, decide if I want to give my SBOM to the user, yes or no? And the answer is yes, I can decide that. The reasons can be security or intellectual property.
Yeah. So you also have to comply with the required SBOM specifications, but at this moment in time, as Pedro already mentioned, the European Commission didn't determine a format or what kind of elements should be in the SBOM, so they can make a delegated act for this. So if you ask me what will be the format or required elements, at this moment in time, we don't know it yet. In any case, if the European Commission is going to draw up this format and elements, they have to consult with experts in each member state. These this slide should not be part. Okay, then we come to the last part of this presentation. Let's see the time. Okay, need to end. So of course we have the law, but you need enforcement because otherwise it's just a legal text which no one complies with. So we have mandatory notifications under the CRA to ENISA, to users, and to the general public. And there are also voluntary notifications. We'll explain them a bit more what it means. So there is in the CRA, there is an important role for ENISA. You should notify actively exploit vulnerabilities and significant security incidents.
ENISA is a European level, correct?
Yes.
So there are also national level.
CSIRTs, yeah,
Yes.
yeah. They, which you'll see in the on next slide, they have to work together. I'll explain it in the next slide. So after a manufacturer becomes aware of a vulnerability or an incident, there is some kind of early warning system. So within 24 hours, they have to make ENISA aware of what happened, what they know at that moment in time. But this only applies to bigger, larger organizations. So it doesn't apply to small and medium enterprises, so very small companies. Then within 72 hours, you have to provide more information, your notification to ENISA, and within 1 month, you have to submit a final report with more information about the vulnerability incident and how you solve it.
These clauses are part of GDPR as well.
Yeah, yeah. So on one of the next slides, we will explain like the interplay between this and GDPR. So it's not only a notification to ENISA, but also to users. In first place, impacted users, and if appropriate, even all users. So also the non-impacted users. When should you do this? There is no like strict deadline for this, but it should be without undue delay. So you should not wait unnecessarily to notify the users. A third possibility of notification is to the general public. So even more people than just the users. And when is this necessary? If the incident is of public interest, whatever that may mean. Who should you inform? No, who should do this notification to the public? That's ENISA or another authority, could also be the CSIRT. Or the authority can ask the manufacturer to do this for them. But in any case, the authority should always consult first with the manufacturer before they are going to inform the general public, which makes sense.
But the manufacturer is likely to inform the public right away.
I don't know, not necessarily, because what we see in practice, and this is more with regard to data breaches, but I think this will be it will be the same for these kind of incidents. Companies are not very well, they are very reluctant to notify to people. Yeah.
At least in Europe.
Yeah. Yeah. They're very reluctant to do that. They are very much afraid of reputational damage. They are afraid of questions from the press and so on and so on. So they have a lot of reasons not to do it. So if they don't have to, they don't do it.
Yeah, just imagine you have a smart lock for a home and you say, hey, we got hacked 50 times.
Yeah.
The last one.
No one is going to buy it anymore. Well, I wouldn't. I wouldn't buy a lock that's not secure.
I would, because then it becomes more secure afterwards.
Yeah, that's what you hope. So yeah, indeed. Yeah,
And
yeah,
cheaper as well.
yeah. Okay.
And I get a-
It could maybe increase sales.
And I get a voucher at that McDonald's or something.
Yeah. So if we look at okay, we have the authority to enforce the provisions of the CRA, but of course you also need fines. If you look at the fines, if you don't comply with the CRA, if you are already a bit familiar with GDPR, the fines in the CRA are very, what I call GDPR-like. So they can be very, very heavy. There are different categories. And of course, you may have a heavy fine, but you also have to take into account circumstances, meaning that the fine should be, I mean, if you already have violated the law multiple times, then the third time you will probably get a higher fine than someone who does it who violates the law for the first time. So you can take all those kind of circumstances into account. So it's not that the authority will immediately impose the maximum fine. A very interesting provision here is that the authority should also take into account the size of the organization. So they cannot impose the same fine to a startup compared to a Google or a Microsoft, for instance. This is explicitly mentioned in the CRA. It's not in the GDPR, so that's why I thought it was interesting to say this. If we look at the fines, so with regard to the essential cybersecurity requirements, so what we just discussed, the fine could go up to 50 million euros or 2.5% of the worldwide annual turnover. So the fines can be very heavy, especially if you know that an incident under the CRA could also be a data breach under GDPR. So you can have multi-million fines under different laws.
GDPR is 4%.
Yeah, it's 2 to 4% depending on the provision indeed.
And I asked 2 might also apply.
Exactly. Yeah. And this is something we don't have in the GDPR, but I think again very interesting. If you provide incorrect information to the authority, there is a separate fine for that. So if you violate the law and you also provide incorrect information, you will have a double fine. And this is also something we don't have in GDPR, but here the law mentions, okay, if we have revenue of fines, it should go back to cybersecurity. For instance, it should increase the number of skilled professionals in the field of cybersecurity, notably women, which I think is a good thing if I look at the audience. We see this is like gender equality is a top priority for the European Commission, and it's a very recent thing that we see these kind of things in law. It's actually it never happened before. So I was
climate change.
Yeah, indeed, exactly, same thing. And it should also help. So if we invest those fines in increasing cybersecurity level, it should help small organizations to comply with their obligations under CRA, or they can use it to raise public awareness about it.
So basically, they say it's reinvested in cybersecurity.
Yeah, exactly. Yeah.
Not
So
on
it's
company level.
no. I think why we have this provision is under GDPR. There are in every member state there are data protection authorities, and in some member states they use the fines to pay their own costs. So they have an incentive to impose a fine because otherwise they don't have money. So that shouldn't be possible. So here it should really it should be a useful fine. I mean, it should not serve to fill the gaps of the government.
Well, I think that's debatable, to be honest.
How you mean?
Why shouldn't it be an improvement of the cybersecurity workforce of the government?
Yeah, but
that
that could also fall under it. So I mean, these are just examples.
yeah, I see.
Yeah.
But coming to your point where you say, well, it should not go to, I should say, why not? Why shouldn't it go back to?
It can go back to the government
Because
as long as they use it for cybersecurity.
It can also be to stimulate research or activities
Yeah.
by companies in
Yeah.
cybersecurity.
True, but
Yeah,
it can
yeah,
also
yeah.
be used for, let's say, something completely different, to mow the lawn on the highway just in front.
Yeah, that's not possible. I mean, under the that's probably a political discussion, but under the text of the law, that's not possible. So now we came to the ends. Are there any other questions?
Wow.
Yeah, because what I heard so far was the obligations that has to be done. But I don't know if I missed it, but what about who have to do it? Yeah, like we talked a little bit that maybe some obligations for a startup is too little, too much, sorry. But like exactly who falls under these obligations?
That's the manufacturers that we mentioned at the beginning.
Okay, manufacturers.
Yeah.
So, okay,
But
sure,
manufacturer is
sure.
very broad, of course. It's not just someone manufacturing.
Okay, so
Yeah.
for example, not companies that provide SaaS.
SaaS is usually excluded, except if it can be linked back to the digital element. But SaaS usually falls under the NIS2, so it's similar, even farther reaching obligations, usually that apply to SaaS.
Okay. Okay.
So for the people online, the question was who should comply with these obligations, and the answer is it's the manufacturer of the product with digital elements. I think it's on one of the slides from you, Pedro. I think it's in the very beginning. If you have a look back at you will probably receive the slides, I think. Yeah, we will send them to you, or you already have them. Yeah. Don't use don't. Yeah, indeed. It is on slides. Let's see. Manufacturer. So it's slide 25 and onwards. There you'll find it.
So let's see if there's any manufacturers still in the room, or people thinking in the same way of manufacturer. This is really a major shift for anybody developing any type of product or service in this game.
Yeah.
And just think about what the implications are if you're developing something that you would like to bring on the market. I mean, it's going to slow down everything, not only the production process and the engineering, the design, but also bringing it to market, because before you bring it to market, all of these things have to be there.
You could be in a competitive disadvantage to companies in other regions. That's true.
Yeah. That's
yeah.
But the idea of the mission is that in the long term, you will have a competitive advantage.
Exactly.
But products from other regions imported into the EU
They
will
have to
also be
comply.
subject to the same.
Yeah.
There is a neutral effect to them.
The Brussels effect.
Yeah. There is, however, a cost effect.
Yeah, because smaller companies will probably have to seek for
More expensive
specialists who can actually do the assessments for them.
This will be very important legislation for most of our clients. I think for a lot of organizations in the digital sector, and
And any business today.
yeah,
is
even
digital.
yeah, actually, yeah, you're right. Yeah, any business, because yeah, it's called products with digital elements, but almost every product has a digital element nowadays. So the scope is like very broad. I mean, could be a car, can be anything, and you have to make the cyber risk assessment. But that's not the only assessment you have to make. If you're also processing personal data, you may also have to make a data protection impact assessment. So you have to do a lot of assessments before going to market. And if something happens, if an incident happens, you really have to make sure that you make the right notifications to the right authorities at the right moment in time. Because you only have 72 hours, and that's under the CRA, but the same is true under GDPR and NIS2, yeah. So, yeah, so it's, I think most companies have to have a look at their internal processes in order to make sure that they can swiftly act if an incident happens, and yeah, bring together like an incident team, or and the technical and legal people to manage it, and to not only manage it on a technical level, but also the legal notifications.
In essence, I think that part is okay to some extent, at least those companies that already have be used to doing something.
Yeah, you would be surprised.
Yeah, I'm not surprised. Definitely not. I mean, I also meet them on a day-to-day basis, but at least those, let's say, the companies that have a process for GDPR,
yeah,
a process for NIS, they will see this as a similar process. So that's a good thing.
Yeah.
But the impact of this is way bigger than any of the above. Because yes, you can do a DPIA, data protection impact assessment, but I mean, you can still shove it under the carpets. You bring the product to market, and then you do your DPIA. I mean, it's still feasible to do that.
Yeah.
Because in many cases you don't even know, okay, what is my impact going to be, unless you actually have put it on the market. Yeah. Here it's a bit different.
Yeah. Yeah.
I think we should not look at it only from a cost perspective, because there is also a huge benefit perspective.
Yeah.
And the benefit perspective is diffuse. It is not specific for, you know, one or two companies or individuals. It will be a society effect.
Yeah, that's
but if you look at all the disruptions we have based on cybersecurity incidents, that's all productivity that stops.
Yeah.
So it decreases the productivity of, let's say, the work in Europe significantly, all these cybersecurity incidents. So if we can reduce those with, I don't know what, 20, 30, 40%, that will be a huge productivity increase, which is a huge gain for the EU. Yeah. And so I think that we should keep that in perspective as well.
Yeah, exactly. We at this moment in time, we see the extra efforts, costs, but you're right, and as Pedro already said, that's basically the idea, that in the long term we will benefit from this legislation. And
I think so.
Yeah, hopefully other what happened with GDPR, like they are copying GDPR everywhere in the world. European Commission is trying to do the same thing with this, and also with AI.
There is a mechanism in the CRA where there is a possibility for the EU to contract with third countries that offer a similar level of protection, so that the obligations are lessened for importers, for example.
So there are some mechanisms to try to incentivize other countries, third countries, to do the same thing and apply the same standards.
Unless it's being challenged, like with GDPR and the data transfers and the umbrella acts.
Yeah.
So some practical questions in the last couple of minutes, and thank you very much, gentlemen, for this. Very useful and helpful. Do you already see requests for helping you your customers with implementation of this today, or do you see it still as in early stage?
Yeah, we have some clients who are like proactive, usually multinational companies.
Yeah. US-based
but-
companies, European?
Not necessarily.
It's usually the Belgian entity that.
Yeah, but they are not like Belgian.
Origin.
Yeah,
They're not necessarily Belgian.
we have a kind of a mix. So some companies are, and it's usually like the more mature companies looking at initiatives like this, but nowadays they have a lot of initiatives to look at. We have a lot of European legislation coming
So, I
coming
mean,
into force.
And in this case, where do you advise them to start on what part?
They are not yet in the. I mean, we also have to. We should not forget that the text is not final yet.
I know, yeah.
So it's very, very difficult for to advise a company. Okay, you have to do this right now. So it's more like assessing what could be the risk. Now, what could be possible that we need to do, but the action is only going to start if we know, like, this is the final. This is the
but
final
some things
text.
you can already start doing, like.
Yeah, but some companies are already doing.
Yes.
Yeah, so I mean, there are companies who are very mature and they already do stuff that would be required under the CRA. That doesn't apply to every
It's in the form
company.
of a memo, or when we do contracting for them, we advise them on what information to include, like limited information from the SBOM, also to inspire trust, but also depending on who is the customer. So
Another thing,
we already take it into account in our contracting as well.
Yeah.
Same with the data, for example.
also with the support period. I mean, the text not final yet, but it's likely that will be in the final version of the text.
The whole incident management process, vulnerability assessment.
Yeah.
Yeah, the support period is also a big one. Yesterday, I had a call with a company that makes smartphone technologies, and we also had to ask what is the product lifetime? If it opens blinds, how many times can it open and close, and what are you willing to offer the customer, and how did you assess the risks, not only from cybersecurity but also product liability perspective?
Yeah, and also from a commercial point of view is also important, of course. Because let's take the example of smartphones again. Manufacturers are more and more transparent about how long they are going to support security updates. A few years ago, that wasn't. I mean, consumers didn't ask for it, but I think, and again, this is also in the spirit of the European Commission making in like the Green Deal, making electronics more sustainable. So you have to be clear to the consumers how long are they going to be able to use their device in a secure way. And a few years ago, there was I think, less interest of consumers to know this beforehand, but no, manufacturers are already more transparent about how long they are going to support security updates. And I think that for some people, for a large portion of the consumers, that's also a factor to look at when they buy a new device.
Right. Yeah, you're using the mobile phone as an example continuously, which is of course sensible, but maybe we should consider also some examples more on, for instance, on the industrial side.
Yeah.
Also considering this environment.
Yeah.
Especially because we don't yet have too many mobile phone manufacturers in Europe.
Yeah,
So-
but I like to use the example because Yeah, okay. This is a very technical audience, but everyone know, yeah, everyone
what is it you're
yeah.
using for. But let's say, let's use a robot, for instance.
Or a PLC, a controller, industrial controller
Oh, yeah.
that lives for 30 years.
Yeah.
40.
Yeah.
So, you know, that's not a simple thing to support.
That's the lifetime expectancy today, but I mean, manufacturers of PLCs can't support that anymore, of course.
Probably not in a
Supporting
useful
30
way.
years of security, that's
Not in the future, probably.
no. So it's a PLC that has maximum lifetime of maybe 5 or 6 years, which will be putting the manufacturing world a bit upside down.
Yeah, but if open process automation will make it interchangeable more quickly and easily, maybe that could work. But those are things that is a revolution in all kinds of aspects, makes it quite involved. Yeah.
All right, thank you.
Thank you
very much.
gentlemen.